All right, Thursday, Judge Chutkan ordered, not a suggestion, not a warning, immediate compliance. Trump has 72 hours, according to court documents that were filed yesterday. That's it. I retrieved the filing, 47 pages, read through it twice. Let's take a look at what I discovered. The order is more than a documents order. It's more than that, up to $3.2 million in possible contempt fines, 14 specific directives, 0 wiggle room. You read the headlines: lockdown, defiance, and so on. These are the things they don't tell you. Quick context: Trump, former president. He's now under federal indictment in D.C. District Court for the actions on January 6th. The problem is that the parties have been repeatedly failing to comply with the discovery orders and witness interview protocols. Timeline, fast version: prosecution seeks campaign records, witness testimony schedules for when a week ago. Trump's lawyers submit motions for delays, says he has asserted executive privilege in 89 documents. Last week, Judge Chutkan dismisses majority of protective claims. Orders will be due by Monday. Monday comes, partial compliance, 23 documents withheld, 3 witnesses who all suddenly disappear for depositions. Wednesday, emergency hearing. Prosecutors show evidence of ongoing obstruction. Thursday morning, it drops the order. That's the setup. How is this order different from other orders? The language: not should comply, not must reconsider, immediate and complete compliance. The enforcement mechanism set out, timeline specific, consequences outlined. Now the documents. Okay, the evidence. First document. The filing was done Thursday morning at 9:47 a.m. I pulled page 12. It reads, quoting, "Defendant's deliberate failure to comply with court discovery orders does constitute willful obstruction of court discovery." That's not my take. That's Judge Chutkan's finding. What is meant? She is saying on purpose, not legal strategy, obstruction. The thing that got me, though, is that page 23, different section entirely, details on what triggered this. Monday's document production included 127 emails. The analysis of metadata revealed that some parts had been deleted. Emails taken from threads equals 34. Add these on to it. You aren't just withholding, you're modifying. I went through the C and take on technical exhibit 3 times. Patterns clear. And email thread from March 2021 with 7 messages created. 11 messages are indicated on metadata. Sequential missing pages 14 to 18 in financial records. Witness interview logs with no protective order, 3 names redacted, all of which are recorded on Exhibit F. Now, what nobody's covering, there is a footnote on page 31, easy to miss, refers to a sealed proffer on Tuesday. Someone talked. The prosecution received original copies of documents by a cooperating witness, which Trump's team said didn't exist. Read that again. They claimed that there were no documents. The originals were turned over to prosecutors by someone. This shifts the definition from non-compliance to false statement to the court. Here's the other half. The order requires more than just documents. Witness access requirements are outlined on page 34. 11 witnesses, each of whom has been delayed, must appear for depositions by Wednesday, June 17th. Defense counsel is not allowed to attend initial interviews, prosecution's request. There are new rules for witness sequestration. They cannot arrange testimony for each other. Latter is a gigantic portion, means witnesses are not allowed to have any conversations with one another regarding their answers to the questions. Can't compare notes. Use at trial. However, when used before a trial, that's aggressive. Judge Chutkan's reasoning is on page 39. Wednesday's emergency hearing shows witnesses were unavailable and that the claims of privilege were coordinated across disparate areas of testimony according to the evidence. Translation: witnesses were getting the same talking points. Fallout: the Trump team has until 5 p.m. Monday to come up with everything. No extensions. After the $3.5 million fine for contempt of court, the fines are set at $45,000 per day per violation. If the deposition of a witness is not taken when it is required, defense waives right to cross-examine that witness at trial. This is the stick that caught my eye, page 41. If compliance doesn't occur, prosecution can introduce adverse inference instructions to the jury. What's that mean? Jury is informed you may draw an inference that the documents that have been withheld would have been adverse to the defendant. In English, jury assumes they made your case worse if you hide documents. That's not nothing. Subscribe. I'm not done. This order had teeth in its tail that were not present in former orders. I will explain to you why this is important. Okay, but look, got to be fair here. The other side is right. Few points, actually. Trump's lawyers and constitutional law experts claim it is overreaching in the name of judicial bias, and honestly, some of their arguments are valid. Their case first, the timeline's unreasonable, 72 hours to review, process, and produce documents that were previously months in the making. They're telling you that it's a failure trap. Second, executive privilege claims take time to be properly asserted. Just because a judge is impatient, you can't be expected to do away with constitutional protection. Third, obstruction of witness coordination is not. It's a common practice in the law. Attorney for defense examinations of the witnesses. That's the job. According to Mike Davis, former chief counsel of Senate Judiciary, this order violates the attorney-client privilege and the basic due process rights. Don't endorse everything of it, but it is not nothing. What they've got, this order is so much more than months. For privilege claims to be litigated, it's days. Inconsistent with legal precedent in which defense counsel may attend prep. This order prohibits it. Not even Andrew McCarthy, former assistant U.S. attorney who isn't a Trump defender, will admit the timescale on this is abnormally shortened compared to a standard criminal procedure. I'm not here to tell you who's correct. Prosecution's interpretation, records of obstruction are recorded. Defense interpretation, it is the process itself which is the penalty. In a hurry to provide grounds for sanctions. Both can be true, which is what makes this difficult. The adverse inference instruction is generally only used in situations where there is clear and intentional tampering with the evidence, not delayed production. If you're the Trump lawyers, you're arguing we're in a state of litigating privilege claims honestly and we're not being prosecuted for going too slow. Well, it is a legal question. Others believe that exigent circumstances of a national security and election integrity case allow for aggressive timelines. Others contend that the case is too important to be subject of a compression of constitutional rights. Pretrial sequestration of the witness is unusual. Defense rebuttal. If witnesses can't talk to each other or counsel, what will we do when we need to defend each other? Prosecution counter, they're fact witnesses, not character witnesses. Facts don't need to be coordinated. Both are reasonable depending on your perception of the situation. What I can tell you what the order is asking for, and it demands full production of documents, no restrictions on access to the witness, and escalating penalties for every day of noncompliance. Is it suitable judicial power or the abuse thereof? This is in the process of being litigated. This didn't come out of nowhere. Backstory, quick. Several months ago, original requests for release made, standard stuff. Trump's camp counters with general claims of privilege. Judge Chutkan clears some, lets others go. Normal back and forth. Then pattern develops. Partially met all production deadlines. There's always a just enough component to avoid sanctions rather than full compliance. The prosecution begins to record it. Files of motion in which there are definite delays. 2 weeks ago, court-appointed special master proposed to supervise the production. Trump's campaign battles it. The final order, so we thought was last week. Looked like it resolved all these conflicts. On record at last Wednesday's hearing, someone said, Your Honor, we've created more than 40,000 pages. We're doing it in good faith. What happened? The deletions were identified by metadata analysis. Pattern prosecution documented, claim special privileges, lower the price, make partial records, claim rests are not there, quickly locate some documents when prompted, repeat every time, delay or extension granted, partial compliance accepted, until the metadata evidence, that is, this changed Judge Chutkan's course from patient to final. The straw that broke the camel back was Wednesday's emergency hearing. Thursday's order was the result, Thursday, 9:47 a.m. Here's what happened. The order came as a surprise when Judge Chutkan delivered it from the bench. No cameras, transcript only. This court's patience has come to an end. Room went silent. What followed? A written order that was filed within 2 hours is 47 pages long. Expansion of discovery powers given to the prosecution. Motions for reconsideration denied. Now, what everyone missed. Page 44, permission to depose Trump himself. Not his lawyers, not his staff. Trump to be held June 18th. That's next Thursday. Judge Chutkan's reasoning. When documents are not being prepared, obtain testimony regarding their contents. Defense objection raised, denied within hours. Then the financial piece, the $3.2 million, is not just a number out of the blue. On page 38, order explains how to calculate based on estimated cost to government of delays, additional attorney time, extended grand jury, witness travel rescheduling. Grand jury costs alone on an itemized breakdown are $127,000. Wasn't reactive, calculated. It is evident in the organization of the order. Specific findings of previous non-compliances are referred to throughout each section. Now, each penalty related to cost or delay documented. This is where things get really interesting. The order includes a severability clause. Legal term means if one part is reversed by the appeals court, then the other remains. Judge Chutkan isn't making just an order. She is creating something that is beyond appeal. Referenced 14 previous cases, cited 23 precedents. All enforcement measures are backed by case law. She's expecting this to be challenged, and she wrote it to meet that challenge. Not just authority, strategy. What is the thinking of professionals? Barbara McQuaid, former U.S. attorney for Eastern Michigan. It's potent and within district judges' powers. This order says, constitutional law professor Jonathan Turley, the compressed timeline raises issues to appeal, which may further delay the trial beyond the original discovery disputes. Preet Bharara, former U.S. attorney for Southern District of New York, this amount of review in 72 hours is extraordinary. Most courts require a week's minimum. If there's a similar legal issue being raised by lawyers on both sides of the issue, pay attention. However, there's this. Former prosecutor from the Mueller probe, Andrew Weissman, saw normal timelines don't exist. Evidence is being deleted. Witness coordination is being used. Obstruction protocol, different lens entirely. Former federal judge Nancy Gertner. The question is not whether she can do this. It's whether the record supports doing this here. That's the place where the legal battle is really, not authority. Application. The compliance deadline will be Monday, and which side will win will be determined then. Why is it important? Real talk, how this affects how power works in America. Precedent. This provides precedent for the court's approach to non-compliance in high-profile cases. Presidential power. Bigger question. What about the implication of a former president being allowed to block a criminal investigation? This order reads, it doesn't fit into this limited set of circumstances. That's important to all future presidents. That alters the nature of presidential power. Not good or bad, different. Some people believe it's a matter of accountability. Some believe it's weaponization of courts. This case will determine which opinion is the law. Who's affected? At this time, discovery disputes for all defendants in federal court, attorneys throughout the nation are reading this order and wondering if their delay tactics are now riskier. What nobody wants to say, uncomfortable part. If you believe that Trump was being mistreated, then you have to wonder, would this order be issued to someone who had no means to keep filing endless appeals? If you believe this is correct, you must ask, would a less well-known defendant receive this many opportunities prior to the imposition of sanctions? High-profile defendants are treated differently in the system. This case is both. How'd Trump respond? Shortly after the order, which was published on the Truth Social app, this isn't justice, this is election interference, and my lawyers will fight this tyranny. There was considerable reaction within the legal community. 3 former federal judges publicly argued that it is inadvisable to attack the judge while on duty. Later, Trump's attorneys formally objected Thursday afternoon. Different tone, professional. States that order is a denial of due process. Asks appeals court to grant emergency stay. Calls timeline unconstitutional. No decision yet on the stay request. In case it is denied, the deadline is Monday. Trump spokesman released statement Friday morning. Now, President Trump has cooperated entirely, and this political witch hunt goes on. And there's a wide difference between what's filed in court and what's said in public. Not cooling down, accelerating. What's still unclear. 1, If the cooperating witness referenced in the sealed proffer is a high-level member of Trump's circle or a lower-level Trump staffer, that matters. Inner circle witness is devastating. Lower level is manageable. 2, the documents which specific ones the metadata analysis revealed that were deleted. Order doesn't say. That's still sealed. Coming events, emergency stay hearing will be on Monday morning at 9 a.m. in the appeals court. A decision will be made same day before 5 p.m. compliance deadline. The deposition of Trump, which is scheduled for Thursday, June 18th, is now in limbo. If he is not found, order makes a bench warrant. That's arrest authority, no previous experience, testing with a former president, position briefing for defense, due Sunday, prosecution responses due Monday at noon, date to watch, Monday, June 15th. Compliance takes place or contempt proceedings commence or appeals court Indari Hall Tower He has everything. We'll find out which way this goes by the end of business Monday. Subscribe. I'll explain what happened on Monday as soon as it does. This is happening quickly, here and now. Order made to be obeyed unless stayed. Compliance clock is running on 72 hours until Monday, 5 p.m. Appeals court to consider emergency stay, decision Monday morning. Trump's June 18th deposition pending compliance. The fines for contempt up to $45,000 per day per violation begin Tuesday if no compliance. Scheduled next week, Monday, June 15th, appeals court ruling on stay plus compliance deadline. If this remains as is, depositions of witnesses will begin on June 17th. If order holds, Trump's deposition is on Thursday, June 18th. Friday, June 19th, status conference on compliance. Sealed proffer content, not public. The deleted document S. The cooperative witness I, D, Judge Chutkan, denied motions to unseal those parts. Sealing is ongoing, continuing investigation, and witness safety needs continued sealing. That indicates that the witness is important and may be in danger. Clock's running. In the next 96 hours, the fate of the order will be determined. The inflection day is Monday. We're here. Trump has 72-hour deadline for complying with own deposition and increasing monetary penalties. This is an order that will withstand appeal. All citations supported by precedent, all penalties based on costs that are recorded. That's a judge that expects to be challenged. Sealed witness proffer, the metadata evidence. Those are the true stories. Assuming that this evidence is as robust as the order suggests, the compliance battle is just getting underway. The actual criminal case gets much harder to defend. I shall be waiting for the result of the appeal in Monday's court. If they remain silent, then there are major problems with the process from a legal perspective. Story's not over, still developing. Subscribe for Monday's breakdown, not just headlines, the actual legal analysis. When that appeals decision drops, I'll go through it, document by document, what it means, what comes next. Talk Monday.